Singapore is bolstering protection against online content used to facilitate scams and other malicious cyber activities through a newly passed law. The 2-hour Parliament debate on the Online Criminal Harms Bill saw MPs from both sides of the aisle asking what the legislation will mean for e-commerce platforms. Also, how the law will apply to harmful online activities perpetrated from overseas. Lauren Ong reports.
Ordinary websites at first glance, but with early indicators, they're set up to scam. With the new laws on online criminal harms, it will be enough for authorities to take swift action.
Malicious actors are also quite kiasu in the sense of preparing much more than the bare minimum. For example, thousands of blank websites are created in advance with domain names that resemble those of legitimate organizations. When the malicious actor is ready to strike, these blank websites are swiftly activated, populated with scam content, and pushed out to the public, who may fall prey within minutes.
9 MPs rose to speak on the bill, including Leader of Opposition Pritam Singh, who says the Workers' Party supports this bill, unlike the previous 2 legislations on online falsehoods and foreign interference.
I support the development of codes of practice for designated online services as provided for in Part 4. Ultimately, a proactive approach rather than a reactive one is certainly important in view of how quickly online scams evolve.
WP MP Gerald Giam also wanted to know how this bill is different.
I would like to seek clarification on how the bill will be able to empower the authorities to deal with scams in ways that existing legislation does not.
The Online Criminal Harms Act, when it takes effect, will take one step further to provide the government with the targeted levers to issue directions against scams and malicious cyber activities, including against online activity that is suspected to be in preparation for such offences. This is the part that is quite key.
The bill also covers all mediums of online communication and a broader scope of online harms, including money laundering, unlawful gambling, and drug-related offences. During the debate, there were concerns raised over enforcement, especially when it involves overseas websites and perpetrators.
Many malicious websites originate overseas, posing challenges in terms of identifying and holding individuals responsible. It raises important question of how the relevant agency would know whom to direct a disabling or restriction direction to. Moreover, why should the creators of such sites who are based overseas comply with such directions? What penalties do they face, and what alternatives do we have if they refuse?
In the event that a prosecution has been brought against service providers or individuals located overseas, will steps be taken to secure the attendance in court?
There are further steps that we can take. First, we can prosecute for non-compliance where possible. Second, the bill allows the competent authority to issue orders to restrict access to the non-compliant online service to prevent the criminal activity and content from being accessed by persons in Singapore.
Codes of practice for online service providers and e-commerce websites will set out outcomes they are required to meet.
Could the Minister give details of how codes of practice will be developed, including what consultations and engagements will be undertaken with the industry?
Mrs. Teo says these will be developed in consultation with the service providers and updated periodically. But in the era of user-generated content, she admits that pinning down offenders could be difficult.
So we have to ask ourselves, what is the priority? If the priority is to prevent harm from continuing to reach our people, you can try and chase down the original perpetrator of the offence, or you can try and prevent the harm from happening first. So we want to be able to do both, but we need to be able to nip it in the bud quickly first.